We don't have that many cases to do in this section. That they all deal with Rule 57, and they all deal with declaratory judgments, which is found in Rule 57. A declaratory judgment is a request by a party for the court to issue a determination as to the party's rights. If you looked at Rule 57, at least the federal rule makes reference to the federal statute, which is 28 U.S.C. 2201. And as it says within the rule, the existence of another adequate remedy does not preclude a declaratory judgment that is otherwise appropriate. The court may also order a speedy hearing of a declaratory judgment action. So oftentimes it is and can be combined with other remedies that you might have. You see it on a breach of contract action, request for declaratory judgment, employment disputes. I pulled off a few here earlier that I'm just going to mention from the web that I found looking at the news. But what it is that there has to be a real or threatened controversy when one party is in doubt as to their respective rights and their obligations under the terms of whatever the dispute is. Sometimes it's because there's threatened criminal prosecution, other times it's because there's a contract. The cases that I just pulled down from the news section, someone filed a declaratory judgment action in one of these legal battles over decriminalizing marijuana. This was in Michigan, where the city was arguing that the police should still have some discretion with respect to what to do with respect to the use of marijuana and to what extent that gives rise to further police action. And I don't know whether you saw it, but there were 3 important cases in Massachusetts last week with respect to what the decriminalization of marijuana in Massachusetts means to to what extent the police can search, or to what extent your growing of it can constitute either distribution or simply a violation of the statute that prohibits private parties from growing marijuana as well. But obviously there's a lot of law that has to be sorted out, with many of these jurisdictions now moving to either decriminalize it or provide for medical use of it. And there's a lot of uncertainty as to what people's rights and obligations are. The case in Michigan is just they're trying to sort through what can happen as a result of it. And we're going to likely to see a lot more cases like that. I found this one interesting because this is from April, and it's a Massachusetts case on a declaratory judgment. I always thought when you go into the store and they're asking for your zip, that they're simply doing it to figure out where their marketing area is so they can better target their advertising revenue. I'm not, after reading this case, I'm not as sure, but if any of you, well, many stores do it. This was Michael's stores. If you go into Michael's and they take your social security, not social security number, your zip code, what this case said, or at least the plaintiff argued, is that what they then did with it is went further and found where within that zip code you were, got an address, and then sent you additional solicitations as a result of having that information. And what the case is about, though, is a suit for declaratory judgment and damages, saying that asking for their zip code violates the Massachusetts rules, General Laws, Chapter 93, Section 105A, with respect to personal information that companies are not, should not take and cannot disseminate if they do. And it's funny because, at least at first blush, I wouldn't have thought your zip code would be such a personal identifying number, but the holding of the court is that it is, and it is in fact a violation of the statute for them to take it. when the cashier asked for her zip code. My guess is Michael's, well, I know Michael's isn't the only one, because there's a bunch of stores where they say, can you tell us what your zip is?
I think on that case, I remember hearing Martha Coakley speaking about it right after the ruling came down, and I think part of the issue was they would say for security purposes they would take the zip code, but in fact it wasn't security purposes, it was the marketing that you're speaking of.
Well, see, I thought what it was, because at times online, I thought it was they want to make sure the credit card matches the zip code, so they're good. Is it shipping to the same address? And then I thought sometimes it's just, well, we want to know where we should be spending our advertising dollars. And from a business standpoint, that makes sense. But they're actually, at least it appears, going a lot further with that information. And again, if I ask and you give it, because I've heard people in front of me say, no, I don't want them. Or, I didn't know this. Maybe it's wrong, but someone in one line once said, well, I'm from Canada. Well, Canada doesn't have zip codes. Does anyone know whether that's true or not?
It's letters and numbers. It's called a mail.
So they don't?
It's the same thing, but it's different.
Oh, okay.
It's 6 letters.
Where's my drink?
With a space in the middle, and it's called a mail code.
My drink over there? I'll get it. You don't need to.
Gary's Canadian, so.
Huh?
Gary's Canadian.
Oh, you are Canadian?
It solves the same purpose.
Well, he's right. I knew he went to Vermont, so I figured that's close enough.
But the database, the retail databases are the same. If you plug in a mail code from Canada or a zip code here, it'll come up with a town and state or province. So it's the same thing.
So they just use letters as well as numbers. They use a different variation.
Same thing. Yeah.
Well, at least it appears that in this suit for declaratory judgment, what our Supreme Court reason is that this is a matter of consumer privacy, and it is in fact a violation. I'm not sure where your damages flow from it, but even nominal damages will be something. And what it says, obviously, is therefore other retailers and businesses may want to review their policies regarding credit transaction and how their employees request consumer information. In particular, retailers and other businesses may want to reconsider whether their employees should request a zip code, even if provided by consumers voluntarily, when such information is not required by the credit card issuer. So it's kind of an interesting case, because I think it's sort of another front on this cyber security and privacy issue.
Well, it used to pop up automatically if someone spends money in the Coach store.
Yep.
Prior to the final sale, they always ask you, what's your address? And a lot of it was for marketing purposes and to be able to keep up with customers as far as their likes and things that they were looking for in the store. So it was just a better way to be able to service your customer.
And a violation of Chapter 105.
We can't do that anymore in Massachusetts. We can't. It's California and Massachusetts. The Coach store will not. So there's no more thank you notes when you spend $3,000 in there. So, I mean, there's now no way for us to really differentiate ourselves from the other luxury brands. So it kind of sucks in that way when you're on the other side of it. So.
Well, but you're using that to further
let me ask you this.
market your products.
You're the customer. You come in and you bought your wife a beautiful handbag, okay? And you've spent a good $800 in there. And for you to get a handwritten thank you note to your address from the person who sold it to you, would that make you feel, like, oh, that was thoughtful?
I think it would depend on whether the guy's wife actually got that pocketbook.
Well, it was for him. We have a problem.
Or for another her. It might be a bigger problem.
It's just little touches like that our store has been able to do that customers have appreciated. And if there's been one that says, well, no, I don't want you to have my email address, or I don't want you to have, then it's no problem.
Well, I'm not sure, and without, thinking about it further and looking at the case further, I'm not so sure why, if I tell you would you like to voluntarily give us your information, your zip code or whatever, so that we can make our products more acceptable to you, or?
But that would be fine, but they were misrepresenting it. I remember the case, and he was right too. The 93 statutes, they were saying it was for security purposes for your credit card, and they were using it for something totally different.
Well, that's what it looks like. But what about? I mean, even this case, and this is from this is a sort of a note from a well-respected law firm in the privacy area, says that even stores that are taking it because of a credit card purchaser might want to rethink that as well, because nonetheless, at least the way this case reads, it's going to be a violation. But again, I think it's probably the deceptive nature of it. But this case was, if I didn't tell you, it's Tyler, Tyler versus Michael Stores, and it was from Massachusetts Supreme Judicial Court decision. So I think that's kind of an interesting one on the declaratory judge. Started out as a declaratory judgment. And then the third one I thought was interesting, and I didn't get the name because it didn't print off the whole thing for me when I asked it to. A confidential informant who's now in jail has brought a declaratory judgment action seeking his finder's fee / reward because he ratted out a big drug dealer who allegedly our government agreed to pay $1 million for the arrest of this person. Our guy has now brought a declaratory judgment action saying, well, you offered the $1 million, I provided the information, you arrested him on that basis, I want my $1 million. So he's got 2 counts on the declaratory judgment that the government has to honor the reward they put out, and I guess is some type of quasi-contract claim that he's due as well. You see declaratory judgments used in a variety of different fashions, usually these days coupled with something else. And so you just, which one? Oh, you got the Michael Store one? There might be an extra copy of that Michael Store one if you want to take it. So let's talk about the cases that are here, because we've got a couple things going on, and this is where you have to start to worry about it too when we start to think about declaratory judgments, because the other things on the docket this week are, and we're not going to go, we'll go an hour tonight, probably just an hour Thursday, because there aren't that many cases, as you can see. But the Anti-Injunction Statute, which I want to talk about, and then the federal and state issues, because in a lot of cases, especially the criminalization issue, the decriminalization of marijuana, some of these other conflicts between federal and state law and the like, that's where we start to see requests for declaratory judgment, because in essence the person may well feel they're between a rock and a hard place. If I comply with one statute, I'm going to violate the other, or if I do this, the government agents are threatening arrest for certain things. And so we do have this conflict between federal and state courts a lot of times, and federal and state law when we invoke the Declaratory Judgment Act. First of all, the Anti-Injunction Statute simply says, as its name implies, is that the court should not be issuing an injunction against another court as a general matter. And what this really is the Anti-Injunction Statute applies to federal to state, is that the federal government, federal courts, should not, as a general matter, issue an injunction against pending state court cases. Let them weave their way through that system for the most part, and respect the state's ability to deal with controversies within its own forum. As a general matter, that's the case. There will be exceptions to that. One of them is the relitigation exception. When the case has already been litigated in federal court, now I need some help from the federal government. Preemption, total preemption, complete preemption would be another argument where the federal court should have the right to step in and prevent that pending state court matter from proceeding. Let's take a look at Steffel versus Thompson, which is the first one in our sequence here. This is one of the old, at this point now, 1974, sort of free speech company town arguments. The petitioners was warned twice to stop hand billing on an exterior sidewalk of a shopping center, and he was protesting Vietnam at that point. And at some point, he brings an action for injunctive and declaratory relief, claiming that if the law is applied to him, it violates his First and 14th Amendment rights. Basically, the argument being that he has the right to voice his complaints, whether people like what he has to say or not. But what he's told is that if he shows up again, he's going to be arrested. And so now he's got a conflict between his rights under the First Amendment and at the same point not wanting to have a criminal record for what he sees as protected activity. And now we've got problems between what state law says he is permitted to do and what federal law says he is permitted to do, at least as he sees it. And we get into this question about, well, can he get federal declaratory relief when there's no federal statutes per se involved? What they're talking about is arresting him for state statutes, and obviously the state would have to recognize his constitutional rights as well. But the question, as he sees it, is, well, why should I have to be put potentially through a perilous state criminal proceeding and a record if, in fact, the federal court can tell me that I have the right to be here? And so they've got to deal with a little bit of these issues of states' rights versus federal rights and the litigants' rights to be able to try and get some resolution of this. So he goes to court, and I guess he's filed in federal court. Has he been charged in the state court?
No, his friend, companion did.
Okay, so well then let's let me ask about that, because I'm going to come back to this first page. But in order to file a declaratory judgment generally, there must be, as various cases have described, a real or threatened controversy. And this is part of the interesting dynamic in this type of case, is it has to be an actual, real, or threatened controversy. But if it's ripened to the point where, in fact, he's been arrested, now the window may have closed and it may be too late. So it can't be, hey, I'd like to know, can I do this? I'd like to know, can I hunt down in the Fells Acre Reservation in Medford with a shotgun? I was thinking. Now, my guess is my answer should be no, and I should be able to find that out by statute or local ordinance, but it's not hypothetical. It's not something you're just thinking about. It's got to be, well, I was there with my shotgun and someone said, if you come back, we're arresting you, and I can't find any statute. But once I've been arrested, it may be too late. So you got to think about the window for declaratory judgments. It's got to be sufficiently ripe, but once it's there, it's too late. So it's kind of an interesting one. You can't jump the gun, or you won't hear it. But if you wait too long, you're going to be arrested. So is there a real or threatened controversy, as we would see with this guy? He has been handbilling. They have told him if he comes back, he will be arrested. He does seem to have some issues with respect to his First Amendment rights. How do we know that's true, by the way, that if he comes back, he is likely to be arrested? You're shaking your head he doesn't?
Well, no, I'm shaking my head because this is wrong on a couple different fronts. I hate this case.
You hate this case?
Because it's not right. Because why doesn't the friend take why don't they take a case that's actual, a case in controversy that's actual?
Well, let me ask you that. Why do you think the friend isn't in federal court seeking his injunction and declaratory judgment?
Or somebody else
He's not
like
raising
that.
an issue?
But could he? Go ahead. What are you saying?
I thought you just said he's already arrested.
He is already arrested.
So he's right.
So wait a minute. Is he too ripe? Well, let me ask you this. He's been arrested for what? Trespassing?
Yep.
Okay. If he, in fact, is correct that he is doing something within his First Amendment rights, then he gets a not guilty, doesn't he?
First of all, it's not within his constitutional rights either.
Well, then he's guilty.
Correct. He's trespassing on private property. He doesn't have the right to be on private property to do that.
So then he's got no First Amendment right.
Correct, I don't believe he does.
Okay, so then but wouldn't whatever those issues attendant with his friend's arrest have to be dealt with by the state court in his state court proceedings, assuming he properly raises it?
Yes.
Right? And this is what I'm talking about by the window. The friend has been arrested. I don't think the friend has a right to go to federal court at this point. If he's got any constitutional rights, the state court has to honor those.
Well, he could go.
Go ahead.
He could go the same way this other guy could. He could say, "I want to go back there and do it again," right? And I don't want to get arrested again. It's the same way his friend saying, "I want to go do it, but I don't want to."
He could.
So.
But then that's got to be what he says, not I'm going because I've been arrested and now I'm being charged with this
Which is
bad
that's the
state
thing.
statute.
But that's the same thing his friend is saying. I want to go do it again, but I don't want to get arrested. So it's the same thing, you know. But he's more right because, you know, this is an actual case in controversies. Well, he's appealing it, right? If he's found guilty in the state level, he can appeal it, right?
Okay, but see, and this is part of the thinking that you've got to think about with respect to this tension between state and federal court rights as well. Judges don't like to jump into someone else's jurisdiction. You've got to respect. They give you a whole bunch of these words here, right? Where'd it go? Considerations of equity, comity, and federalism. It's the respect for each other's judicial process within areas within their own rights. And with some of these cases like this, we have federal statutes and state statutes that each could potentially affect it here. But if he's got constitutional defenses or any defenses in his trespass situation in the state court, then that case has to be allowed to proceed through the various levels in state court without a declaratory judgment at this point, because you've got a real controversy. It's not just real anymore. You've been arrested. Due process means allow that case to proceed. And if he's got challenges, the place for him likely isn't to take it to federal court, but it's to try and have those issues heard in state court. What our friend here is trying to resolve is that I don't want to be taken through podunk state court at every level. I want the federal court to recognize here my rights as under the First Amendment without having to be put, as he sees it, through that ordeal. So I understand your point. I think the friend's problem is bigger than Stifel's problem, because the friend has already been charged. Now due process has to take it. If he's got First Amendment rights, then that's going to be resolved in state court in all likelihood. Although if you look at the notes beforehand, it says it says federal declaratory relief is not precluded when a prosecution based upon an assertedly unconstitutional state statute has been threatened but is not pending. And that's the difference here, is that, friends, it's pending, even if a showing of bad faith enforcement or other special circumstances has not been made. The problem is the friend is stuck really sort of in this Anti-Injunction Act. And he might get lucky and get a court to step in. I think one of the next cases we see that. But at this point, Steffel's in the better position to move forward, because he doesn't have anything pending in state, and he's got some real proof that if he comes back, the likelihood is he's going to suffer the same fate as his friend. Go ahead.
But then he could ask for injunctive relief. He dropped the injunctive part.
Who could ask for injunctive?
Steffel, the other guy, the guy that wasn't arrested.
Correct.
So he dropped that piece, that part he shouldn't have, if that's what he's really after, right?
Well, I think he's looking for both. I think he's looking, if he gets a declaratory judgment, then he's good, because they shouldn't be enforcing that against him. And what ideally he would have liked is both the declaratory relief and an injunction against the enforcement of that statute. And what they're saying, what he's trying to argue here, is there's bad faith enforcement is what's actually going on here. If you look at Roman numeral 1, they talk about the actual controversy requirement and the concerns about whether it's speculative or real. And I think we can resolve that in this case pretty clearly, that there is a live and acute controversy that's going on here. But the problem still is we're asking the federal court to step into the state court to try and resolve this issue. And I think what the concern is that it has to be done with the great recognition that the states have the right to deal with cases within their own jurisdiction as well. I guess, and I'll put this to you, Gary, I'm a little surprised that you'd be willing to allow the friend who is in fact has pending criminal charges an ability to sort of opt out of that system where whatever constitutional defenses he'd have would still have the right, he has the right and the state has the obligation to honor those in the state court system. I think Steffel's a cleaner case for the federal court to potentially get involved because we don't have this states' rights issue as solidly there once the state court case is pending.
If he didn't drop the injunctive portion of it, I could follow that, but because he did, I think it makes it less. I think this is, first of all, I think it's an activist court that's stretching the case in controversies to take the case where they shouldn't have in the first place, and it's also a states' rights issue. But that aside, answering your question, if he didn't drop the injunctive portion of it, I could follow that. But because he did, he's just looking for declaratory judgment. I'm thinking that I don't get it at that point.
Yeah,
it's like now he's trying to pass the federal court to tell the states what to do before anything even happened. Injunctions before it happens, not declaratory relief. Right?
Well, but in order to get the injunction, there's got to be a declaratory relief that the state statute is unconstitutional as applied to him. Is it an activist court simply because Brennan's writing?
No, there's two or three areas where I think they're activists, and that the rightness and case in controversy is the big one, obviously, but also.
But wait a minute, though. Let's slow that down. How can this not be sufficiently ripe? Do we really doubt that if he goes back, he's going to suffer the same fate as his friend?
Well, you don't know until it happens, right? So.
Well, is that true? I mean, really, is that you're saying? Unless it's 100% certain, we don't know, or
there's no
more
case
probable.
So it's a case. It's in the Constitution. It has to be a case in controversy.
He's trying to avoid that.
So there's no case until something happens, right?
No, because this is the point about declaratory judgments. You shouldn't have to risk your freedom, and that's what, in essence, you're doing, risking your freedom to challenge what you think is a statute that isn't legally valid.
I'll pull this sentence right here. It's not necessary that the petitioner first expose himself to actual arrest or prosecution to be entitled to challenge a statute that he claims deters the exercise of his constitutional rights.
Yes, and that's where I disagree with it. I think that's activist. Because where is that in the Constitution? Where are they getting that from? They're getting it from a case. It's just case law.
But then help me, because it almost sounds like because the window on declaratory judgments is such that once there is the actual controversy, the arrest, the likelihood of getting a declaratory judgment is now lost.
So that's where the injunctive has to come in. That's what I'm saying.
But you can't. How are you going to get an injunction without a determination that the statute's unconstitutional as well?
It's not. That's the problem. That's why they shouldn't. That's the other third.
Wait a minute though. So you're saying you got to get an injunction, but you never will because that's.
It's not a constitution.
Okay, but so what kind of argument is that? You can't get a declaratory judgment. You should have to get an injunction, and you never can get an injunction because you have to find the statute's invalid first.
The federal court should not have taken.
Well, that's circular logic, though.
Exactly. The federal court should not even have taken the case in the first place because there's no federal question.
Okay, but how do you respond to Ash's point about, so then go, suffer an arrest, potentially a conviction, let's make it a felony even, a felony conviction.
And then try to seek declaratory.
And then try to get relief simply because you were wrong about your status. As you say, I'm on this side of the street instead of this side. I was mistaken where
No.
The private land started and the public land existed.
Well, that's a different issue. That's not in this case. But see, now here's the argument. So let's say that the original Steffel takes.
Well, wait a minute. When you say that's not in this case, how is it not? Because we would agree on public land, he's got a right to exercise his free speech.
Yeah.
The only reason he's potentially being arrested is because their argument is that that's not public land. This is our private property.
That's where the Superior Court should have refused. The federal court should have refused the appeal, saying it's not a federal question because this is private property. You can't. It's not a freedom of speech issue. And then it would have shifted it back down. And
Well, wait a
this person would
minute. They've got to make a determination that it's private property or public. I don't disagree with you that
They
it
deny the appeal. They're making a determination. They're saying it's not a federal question. Right? And then at that point, it tells all the defendants or potential or the plaintiff, in this case, that's bringing the case, you don't have a First Amendment issue here. And then everybody realizes, okay.
But you realize saying that you don't have a First Amendment issue, in essence, is a declaration of rights that you said they shouldn't be entitled to get.
So whether they kicked it out from rightness or federal question or whatever issue, the appeals process stops at that point, and it sends a message all the way down that that's the case. That's what it is.
Okay, but wait a minute though, because we still have the problem with the Declaratory Judgment Act is designed to try and ensure that parties can get a declaration of their rights without breaching the contract and incurring damages, or without getting arrested for what they believe is legitimate activity, or this your decriminalization of marijuana and the attendant uncertainty that leaves various laws in, frankly. The fact is that we want. Some company wants to just take Michael's situation. Some company now says we would like to voluntarily take social area code information. Can we get a declaration of rights that voluntary acceptance of it does not violate this statute 105? Well, I mean, or should they? Well, we're going to voluntarily take it and then hope that we don't get sued by a class action of plaintiffs who say this violates the statute as well. Now you owe $100,000 to the various class members. I mean, in this case, I think Gary is arguing that you shouldn't have declaratory judgments, period.
No, the appropriate court. So that store.
When you say the appropriate court, I'm not sure what that means. You're saying he could seek it, he just shouldn't seek it in a federal court, he should seek it in a state court because it's a state statute.
Well, he needs to go up through the process, and then when some court along the way...
Wait. Up through the process, I don't know what that means. Does that mean get arrested?
No. If he could still take his case, at some point...
Take his case where?
He goes up the chain.
No, I want to know up. I know he can go up. I want to know where he starts.
Starts in state court.
Okay, so
the highest state court before he gets to the...
Okay, so his action... You don't like the conflict between the federal and state courts in this case.
That's another issue I have, yes. But, because he seems like he's skipping the process. He doesn't have a case in controversy that was, okay, so he doesn't want to get arrested, I understand that. So he appeals to the highest state court. The state court says, that state court says no, whatever, you're going to get arrested because it's private property. And he doesn't like that decision, so he appeals it to the Supreme Court or whatever, okay?
Doesn't like that decision.
But the federal district court, I guess, next. And then, again, this is what happened here. He went to the district court. And if he doesn't like the decision, he keeps appealing. Somebody along the way is going to say, I'm not taking the appeal because you don't have a... They don't have to make it declaratory. They could make a declaratory judgment, but they don't have to. They could just say, I'm not taking the search, I'm not taking the appeal because you don't have standing in this court because you don't have a federal question or you don't have rightness or you don't have whatever.
But he must have a federal question or it's not a standing issue. And I don't think in this case, I do think that it is sufficiently ripe that, just as Ash quoted, I think, the correct language. So the problem is, we could say he should start in state court. But we make that decision all the time with our cases. Okay, I've got a case that can go to federal court or state court. where do I think I'd have the better chance of success? And the fact is, I think you're more likely to get that First Amendment treated the way you might, at least this petitioner would like to see it treated or exposed or explored at least in federal court as opposed to state, where he thinks the state looks like they're simply going to follow the status quo and enforce these criminal statutes. I think if you don't allow him to go now, then he's not getting there until, and I don't think he should get there, till after those state prosecutions are fully finished, and that means all the way up the ladder. Just as Gary's saying, is he gets tried in the district court, if convicted, he can take his appeal and his appeal to the state, and then a couple of years later he can jump over to federal court and maybe at that point have a further exploration of his First Amendment rights. The problem is, okay, that's great as we sit here. That's enormously expensive, and in the same vein, he's now a convicted criminal. Wow, the war. There's 74 at this point. But that's right. And I think there's always one way to fight it, is it's not sufficiently ripe, and then, you're too late. But these types of cases apply. I mean, that is one of the things we argue about. But the problem here is, and that's why I think this is an interesting case, I think he's got as ripe a controversy as you can get before it's too sufficiently ripe that they won't hear it. Okay. Go ahead.
One time, so we take his the language you read, I remember reading it too as well.
Yep.
I highlighted it as well. But the court, instead of saying that, should have said, we're not taking this case because it's not right. That person has a case of controversy, but you don't. And except there's 7 other people.
But wait a minute, though. That guy doesn't have a case of controversy for declaratory judgment because that guy has been charged criminally. It's too late for him.
Yeah, so,
And he's going through the due process.
And he's got to, and again, this Anti-Injunction Act says maybe we can step in, but the better rule is, no, you got to step back at this point. You've got to show respect for the state's ability to deal with its statute within its borders. And so there's actually, frankly, less of a reason, and I think a less likelihood, that they would consider declaratory judgment for the arrested one as opposed to this guy.
why? Because he can get his conviction overturned, and he can go do it again if he gets. That's why he wants to take it.
Yeah, but see, we sit here, I think it's easy for us sitting in the classroom to say, oh, he'll get the conviction overturned.
That's what he wants.
He'll get his right to vote again once he gets that felony removed. Well, but that's a pretty big risk you're asking an individual to incur as a result of someone who simply wants to exercise what are their guaranteed First Amendment rights.
See, I say the other guy that got arrested, his companion that got arrested, has more of a case because he wants to get his conviction overturned. He has an actual case.
Then tell me how doesn't the Anti-Injunction Act say that the federal court has to stay the heck out of that case?
Yeah, for an injunction, but for to have his conviction overturned on appeal, that would be more of a case in controversy in my opinion. So I'm going the opposite of you on that one, saying whether or not he wants to go protest the war again or not, I don't care. But he wants his conviction overturned. He's got a right to appeal that all the way up. Say it's my First Amendment right.
Of course he's got a right to appeal it all the way up as a convicted felon, right, or whatever it is.
Exactly. He's got more of a case.
Exactly.
He's got more of a case,
Not for declared.
But absolutely right, Ash, but not for declaratory judgment.
Yeah, you keep flipping it, that's why I know.
But I don't keep flipping it. This is the lesson this week is on declaratory judgment, and so it's something you've got to look at to try and figure out, because at some point it's too far along. And listen, part of your detention that you've exposed, on my book it's 465. It says, a storm of controversy raged in the wake of ex parte Young, focusing principally on the power of a single federal judge to grant ex parte interlocutory injunctions against the enforcement of state statutes. And then it lists some language there. That is the problem, right? I mean, out of respect for states' rights, who is a single federal judge? And this is even the worst possible example, without notice to the other side, to issue such an injunction shows such a lack of respect for the state court that's where the problem came in. I'm not so sure, I don't even forget that language. This isn't that case. The state would have an opportunity to be heard, but we are, at least temporarily, going to chill his First Amendment rights because, as the case said, he's stuck between a rock and a hard place, Scylla and Charybdis, right? Either he can't exercise his First Amendment rights, and so he's been denied something that we feel is fundamental to him, or he can exercise them and risk potentially exposing himself to the criminal justice system. And respectfully, I think that's easy for us to sit here and say that, well, that's all. So he'll be arrested, he'll be held overnight, at some point he gets bail, he gets fingerprinted and all the rest of it, and at some point maybe he even gets vindicated years later after spending God knows what trying to have his presumption of innocence protect him. That's nice. That's nice in theory, but if I knew I'm not supposed to go back because they will arrest me, then I won't. And that's the point about the declaratory judgment. The problem is that he could decide to sue in state court, but I think he feels the state court's not going to give him that right. Then we don't have the conflict. But we would still have issues about whether he's going to have a criminal record, and he simply wants to avoid that, which I think the court is correct in saying we're not at a stage where it's too ripe, and the fact is we could examine whether this is appropriate. Gary's simply saying, well, it really is going to turn on a question of fact, which I don't think any of us dispute. Private land or public land? And even private land, has it become sufficiently used that the public's always there? And it would seem like a pretty easy factual determination at some point to be able to make. And then the question is, well, who should be making it? I thought it was interesting that page 471, 471, there's a footnote here from, I think it's 19. And it says, the pending prosecution of petitioner's hand-billing companion does not affect petitioner's action of declaratory relief. In Roe versus Wade, which is a case you're all familiar with, obviously, while the pending prosecution of Dr. Halford under the Texas abortion law was found to render his actions for declaratory and injunctive release impermissible. So you all know the case of Roe v. Wade. No one knows this poor Halford guy who actually was arrested and charged with the violation of the statute and denied his right to injunctive relief because he had that pending criminal case. But it didn't prevent granting plaintiff Roe, against whom no action was pending, a declaratory judgment that the statute was unconstitutional. It's the difference between the window being open and the window closing, because once the state has stepped in and charged, at that point, out of comity and federalism, the federal court has to give the state the first chance through its various levels the appropriate respect to resolve that action in accordance with the law.
Can you look at the next paragraph down to, this is where it really gets me. The next paragraph underneath that, footnote 19, it says Congress's intent to make declaratory available. Whenever I read Congress's intent, okay, that's when I see activism. Because they're trying to, if Congress wanted to intend that, they should have wrote that. Because obviously
well, but you know they likely did,
well,
right? I mean, legislative history is important to understand what the intent was.
Yeah.
You wouldn't argue that the court should never use legislative intent to interpret the statute.
I'm not arguing that, but that's when it just opens a red flag for me to go then and look at the actual statute and then obviously look at the legislative record. You know, because then I'm going to obviously find that the court went beyond Congress's intent. Usually, and even the paragraph before footnote 19 seems a little, to me, a little activist. It's saying it's saying that declaratory judgment has the force and effect of final judgment, and they say, but that's not as powerful as an injunction. I'm like, how can it not be? You know, so that just, to me...
Well, because an injunction carries with it the threat of contempt, and a declaratory judgment does not.
But
I mean, that is...
doing something that's against the law, so you're going to get arrested. So, you know, what's the difference, you know, so...
Well, no, the difference, as I just explained it to you, is that if he violates the injunction, he potentially risks contempt. You violate a declaratory judgment, you potentially risk damages or other things, but it's not necessarily, it won't jail you because there's no order specifically to you to do certain things. And I do think that that's a difference. But I guess I'm still a little, I am a little uncertain, because it's not just the case. It would appear to me you don't like the notion of a declaratory judgment ever.
No, there's obvious cases, and the state court can issue it too.
I don't disagree with that.
You know, it's just, I'm just thinking that here, they're overstepping their authority, I think, to do it.
Okay, but then the alternative is...
And they're setting precedent. That's the big one.
I think this is completely consistent with decades, maybe centuries of earlier precedent.
I didn't read all the cases and do my
No, but okay, but wait a minute. What would you have him, tell me what you would have him do otherwise?
They say the other cases they cite here don't give them that, but they're going to do it. That's what they're saying here.
What would you have him do otherwise?
I would say just deny the freaking appeal and then tell them the message loud and clear, you don't have a case.
But how do we know he doesn't have a case yet? How can we possibly know on the record that we have in here that he doesn't have a case?
Well, the appeals court...
I thought we both agreed if he's on public land, he's fine. Well, what? I haven't seen a floor plan of where he was. None of us have any of those facts.
The appellate court has to make that determination. They can't just take any case.
But wait a minute, though. I asked you a question specifically. What would you have him do? If not this, and anyone can answer it. If not this, you tell me what his choice is. His choice is to go down there with the handbills and get arrested, isn't it?
Or not do it.
Okay, so sacrifice his First Amendment rights.
No, because the appellate court, the higher court said...
No, you said not do it. The two choices, as I understand what you're saying, not do it or do it and get arrested.
The higher court, when it looks at the appeal, says there's no federal question here. That says it, and we're not taking it because of that. Then everybody's on notice that it's not a First Amendment issue. The higher court...
But we agree that free speech is a First Amendment issue, right?
The higher court will look at all the facts and they'll say...
Gary,
yes.
We do agree. And we're giving you ample free speech tonight. That's, no, but we all know, right? I mean, you can't... You've got to work with what's here, right? So he is arguing a legitimate free speech point. Your point is... Your point isn't... I think your point is important. It's going to depend on where he's located.
Right, and the appellate court looks at that.
But how could they look at it? None of us know. The record hasn't even gotten to that point where it's been explored.
Right, and then they say we can't take it.
So the question is, though, and you've been dodging it, what would you have him do? What would anyone else have him do? See, to me...
If I was his lawyer? Or what do you ask? Or if I was him?
I'll take any answer as to the question, what would you have him do? If not this, what would you have him do? Because by the way, I'll give you a minute to think. I think this is the perfect case for a declaratory judgment. I think it's a problem because we add into this, and this is why I have you read it, we add into this conflict, and it's a serious conflict between states' rights and federal rights, okay? Because federal courts shouldn't just willy-nilly jump into pending state court cases, and they recognize the problems with that. But the fact is, what would you have him do as the alternative is really the problem here, because he legitimately, I'll assume it's legitimate, feels that I've got free speech rights. And it could be many other rights, but he feels it's this. Listen, you don't have to like the issue. Maybe it's the right of abortion. Listen, I think those people that protest the funerals of the dead soldiers are the most reprehensible people. Yeah, most reprehensible people in the world. But do they have free speech rights? I mean,
at a distance.
Huh? At a distance. So where's the distance? And wouldn't they have the right to get declaratory judgment? I mean, and that's the thing is, you don't necessarily have to like the speaker, but we have to recognize there needs to be avenues to be able to explore those legal rights. So what would you have them do? Because if you can't have declaratory judgment, it's get arrested, right? Or just not do it.
Because the appeals court said, looking at the facts, you're not on public property. You are on private property. We're not taking the appeal.
Where does it say that?
Denying this. But that's what they should have done. The higher court looked at the facts and said, is this person on public property or not? Right? What am I missing?
You said they said it. I asked you where, and you said that's what they should have said. Because really, right? We never get to that point, and that's the problem because we dance around the legal issues. This may well turn on a simple factual determination. Where was he? right? If you're
Or we can't take the case because you didn't tell us where he was.
He was in front of the
Right.
shopping.
in front of the shopping mall.
So that's private property. He was on the
Whoa!
He was on the side. He was on the sidewalk in front of the store, if I remember reading it correctly.
Well, but who's the sidewalk belong
But
to?
the appeals court then said there's not enough facts here for us to take the case. We're denying the case, right? We don't know where this.
But you would
person
give him his right to appeal. He takes that, and the Supreme Court says otherwise.
was. Yeah, they're activists.
And by the way, all they're saying here, it's not saying he gets it. It says, if you look at it,
Right.
that
doesn't say.
it may be appropriate to be able to grant him federal declaratory relief when there's no state prosecution pending and the federal plaintiff demonstrates a general threat of enforcement of a disputed state criminal statute, whether the attack is made on the constitutionality of the statute on its face or applied. All they're simply saying, there's no absolute bar under the Anti-Injunction Act. He should have the right to see it, to have the court take a look at it and make the determination before he has to risk exposure to the criminal statutes. To me, and that's why, in looking at it, by the way, I think the dissent, no, the concurring opinion is very solid as well. All we're trying to do here is figure out what's the right path for this person to be able to exercise his rights without having to suffer arrest. And I actually think it's a good case on the funny distinction between the window being appropriate before the window gets too open, such that I don't see his partner as having any chance of a declaratory judgment with that pending criminal case. Whatever constitutional rights he's got there, they have to have resolved in the state court at this point. And footnote 4 in the concurring opinion, sensitive to principles of equity, comity, and federalism that they recognize in Younger versus Harris, federal courts should ordinarily refrain from enjoining ongoing state criminal prosecutions, which we all agree to, right, Gary? That we're all in agreement on. But I think there also has to be an exception for the federal court to right wrongs when it's a bad faith prosecution or there's other issues pending in that state court that just don't make sense, that no one should have to suffer arrest, conviction, incarceration if it's being made in bad faith. Take a quick look at Mitchum versus Foster and we can resolve this when we meet next time. But this is a 1983 action, and it's a suit in equity for the deprivation by someone acting under the colors of state law of their constitutional rights. And this is an interesting case because, again, it talks about the Federal Anti-Injunction Act, and it starts out by telling us the Federal Anti-Injunction Statute provides that a federal court may not grant an injunction to state proceedings in a state court except as expressly authorized by an act of Congress or where necessary in aid of its jurisdiction or to protect or effectuate its judgments. So if you didn't like the last one, you're not going to like this one at all. But what I wanted you to start to think about here, and it's for next week's cases as well, it says that the bookstore was being operated as a public nuisance. At least that was the argument here by the prosecuting attorney. What's a public nuisance?
Versus private nuisance.
Yeah, I understand what it's versus, but I mean, I assume that you learned in torts what a public nuisance is. So can you define that for me? Because next week we've got a lot of real property cases where talk of difference between trespass to property, nuisance. You all know
Yes.
what those are you do? So what's a public nuisance?
It deals with the public in general. It's essentially,
Yeah, that sounds like I could ask a high school student to give me that. So how about give me something like for the bar exam? What are you saying?
Like an unreasonable interference with like public health, safety of the community, something to that sort.
Sounds close to English. What was it?
Unreasonable interference with public safety regarding a community, I guess.
It's closer. Still a little jumbled at the end. You want to try it again? Well, your colleagues aren't being of any help, just for the record. You're the closest we've got right now, TT. You can't define nuisance? You can't define public nuisance for me? You know there's a big test at the end here before you get to be admitted as a lawyer? You know? And there's a test here too. But
Is that called a final?
the final, I'm not worried as that much as about that big test. Lots of questions, little bit of time.
Unreasonable.
Do you get to use those red papers during the test?
Right now,
Unreasonable interference. Did you look it up there? Did you Google it on me?
carries on.
With the right common to the general public?
So what is it? Interference with the right common to the general public? I think TT was closer.
That was very good.
Oh, it just sounds it. I don't
I
know.
bought it.
What was yours, TT?
Unreasonable.
Yeah, she had unreasonable interference.
with
Did you say that? You said unreasonable interference with what?
the health, safety, comfort of the community.
But it must be in greater.
Must be greater what? You got a better definition? Because she's got now unreasonable interference with the health, safety, peace, comfort, or convenience of the community.
But the injury, that plaintiff's injury must be greater than the general public in and of itself.
So what's that mean? How do I put the two together? So what's a nuisance generally? Because that might be better. Define nuisance, then we can define public versus private.
An activity. It's an activity. A nuisance is something that actually interferes with your quiet enjoyment, your...
Okay, so a nuisance is a interference, any interference, or does it have to be unreasonable? And that she used unreasonable for?
It can be unreasonable.
Oh, it can be? Or it is?
It is.
So nuisance is a nuisance as a general matter is an unreasonable interference with, you said, quiet enjoyment. Is that's how it's defined?
That's a private.
That's a private. I mean, but
That's a private nuisance? That's all that's required?
There's more elements.
Yeah, there are.
What I remember from courts, it's like it has to be suffered by like community as a whole. So
It's like?
it's public. So
Don't you have that red stuff there?
listen, this is the definition.
So what did he give you? Let's hear it.
Defendant maintains...
Is this nuisance, public nuisance, or private nuisance? Public nuisance. What's nuisance?
It just has private nuisance and public nuisance.
Okay, why don't you give us public first as to what he has.
Number one element, defendant maintains or carries on a public nuisance. Number two, plaintiff's injury is different in kind from, not just greater in degree than, the harm suffered by the public generally.
But he has to define nuisance in that.
That's it. That's
Oh no, he's got to give you a definition of nuisance somewhere there. What the hell good is that?
my thoughts exactly.
Okay, Teeny's teaching that course from now on. No, he doesn't define nuisance in there?
No.
Okay, listen, Thursday night, your assignment is to come back with a decent working definition of nuisance, and then private nuisance and public nuisance, because I can't tell you how many times I've litigated this with individuals, okay? This is what people litigate, right? They litigate their neighbors next door. They litigate their neighborhood issues. Their house is their biggest investment. And I've had more than 2 handfuls of these types of cases. And so you need to know what a nuisance is. You need to know for the bar exam, but you also need to know that this is what people will often litigate. The difference between trespass.
I did too.
Huh?
I had to write it because I can't.
Okay.
A use of property or course of conduct that interferes with the rights of others or their property.
right?
But you said a use of property. Couldn't I constitute a nuisance?
It could be even a smell, like it could be rights of control.
Public right.
You gotta have public health, public safety.
Well, but that's for the public. I think we need to define nuisance, and then private and public.
Unreasonable interference with public safety, health, and welfare. That's something.
Which needs to be more. Which needs to be substantial.
Come back Thursday with a working definition, and I want to know trespass as well, because next week's cases deal with that as well. And I'm going to ask you about various things, whether it's a trespass or nuisance. I've had cases in the past with paint smells, lights, old dilapidated boats sitting in someone's yard.
My neighbor.
Well, there's stuff, we can go out the back way here and across the way. You probably see it, those of you coming up from 93. There's a farm there. It's got all these old trailers and cars and all sorts of crap everywhere. What does that constitute and what can we do about it? And you need to know, this just happens to be a pornographic bookstore. But we've actually had that issue in our town as well. They thought they were clever. They zoned it for the dump. They wouldn't give them a place for a transfer facility. Said, okay, I don't want a transfer facility. I'll put the pornographic bookstore there. Or actually, it was a gentleman's club, is my recollection. And then they said, nah, you're not going to do that either. And he says, well, if I can't have the gentleman's club and you won't give me the transfer station, then it's an unlawful taking and you owe me for my property. So pick one of the three, but this is going forward. So we'll talk about that next time.